The battle over immigration detention is intensifying tonight, with federal courts now weighing how long people can be held without seeing a judge. In a significant win for the White House, a new appeals court ruling gave the administration more legal cover to keep that policy in place. Fox 4's Casey Stegall is live to explain what it all means. Casey.
Hey, Heather, this new decision could carry some pretty major consequences, strengthening the Trump administration's hand when it comes to detaining migrants who are being held without a bail, something that immigration rights advocates argue violates their constitutional rights.
A panel of judges at the 8th Circuit Court of Appeals on Wednesday changed the rules for thousands of immigrants across 7 states. The St. Louis-based court ruled 2-1. Federal law doesn't just allow ICE to detain people who entered the country illegally, it requires it, even without a bond hearing. It's the second similar ruling from an appeals court on the matter.
Prior to that, there was the interpretation that they would allow for bond proceedings. Many of the detainees could file for bond and be eligible for bond, and they could grant bond.
The impact is immediate. In Minnesota alone, hundreds of people swept up in recent ICE operations in the Twin Cities filed for release, and nearly every federal judge in the state had been ruling in their favor. Now that's over.
It applies to those that are in the country and basically entered the United States without any DHS encounter, any arrest, any detention along the border, basically an entry without inspection.
Last month, the 5th Circuit Court, which oversees Texas, Louisiana, and Mississippi, made a similar ruling, siding with the administration. Wednesday's decision extends that policy to 7 more states. Attorney General Pam Bondi called it a massive victory, posting on X, quote, "The law is very clear, but Democrats and activist judges haven't wanted to enforce it." Opponents, though, are fighting back on constitutional grounds, arguing detention without any hearing violates due process. And with no clear consensus, the High Court may have to settle it once and for all.
It's starting to look like we're going to have a circuit split, right, as far as the interpretation goes of the law of the statute. And so when it gets to that point, you will likely see it go back up to the Supreme Court.
So federal law does state that immigration officials can grant a person parole under certain humanitarian instances and also other public interest grounds, but legal analysts tell us that is highly unlikely.